My name is Robert Perkins. I'm a practicing immigration attorney for 30 years now. Hard to say 30 years, but it is actually almost 31. And I am pleased to moderate this wonderful panel on the battle for extraordinary immigration and COVID-19 for entertainment attorneys. We have some phenomenal immigration attorneys on this panel who have a great deal of expertise in the various different kind of visas that are used in entertainment. First, we have Zoe Kavork, who practices here in the LA area, and she has a great deal of years of experience in the area and is very well known. We also have Fabricio Lopez, who also is in-house counsel for a large entertainment company here in the LA area, as well as an adjunct professor at Loyola Law School. And finally, from lovely Charlotte, North Carolina, we have Leah Kushner, who's a partner who has many years experience also in immigration law. So I want to welcome everybody. Thank you very much for attending. Especially in these times. We hope we can enlighten you a little bit about the basics of the different entertainment visas and how they're going now, but also to update you generally regarding what's going on with COVID-19. Is immigration still operated? What are the issues that, that we're seeing come up during this crisis? A little sort of hot off the press, or almost hot off the press update. I think many of you know that President Trump has tweeted that there will be a stoppage of immigration. However, he has since clarified this to mean a stoppage in issuance of green cards. We still don't know what the details of that are. It doesn't mean just green cards issued by embassies and consulates for people coming in. Does it apply to marriage cases? Does it apply to entertainment green cards? Would it apply to people that may be changing their status to green card here in the United States? We don't know any of those things yet. So that's an interesting development, and it's supposed to be for about 60 days. In addition, I'm curious, and I'm going to address this question to Leah Kushner, about some of the things you may be seeing in your practice. I'm going to raise one of them, and a similar thing just came up in my practice, which is what happens to all the people that are laid off and terminated and furloughed as a result of all this? Are there things that entertainment attorneys and immigration attorneys, pitfalls that we need to be aware of in advising our clients before we get into the basics? Because I would imagine that this is coming up for a lot of you in your practices.
So unemployment is a state-by-state comparison. One of the biggest problems you have with the non-immigrant categories, or someone here on a temporary visa, is that they may not be ready, willing, or able to work because, in fact, they need a petition filed with the immigration to be able to work. So a lot of states, it's not even an available option. During this COVID crisis, we're seeing different states have different interpretations. From a practice standpoint, we have a big concern with any of the non-immigrant visa categories applying for unemployment, because what it does is trigger a material change in the terms and the conditions of your petition or the employer's petition. That change requires a notification to the immigration, and therefore it is going to trigger a 60-day grace period wherein the person now has to either leave the United States within that 60 days or file to change their status, either to that of a visitor or if they get a new job offer. So we do not recommend the unemployment benefits under COVID at all.
Okay, well that's really interesting. So, you know, for those of you that are practicing entertainment law, those are some interesting questions that you might want to go over with Zoe or some other immigration attorneys, because those are serious issues for your clients. Or with Leah, I'm sorry. I want to introduce Zoe to talk about what are temporary visas, permanent green cards, sort of give us the lay of the land with the language and terminology of immigration. Thank you, Zoe, for getting started.
Yeah, thank you.
If I can clarify really quick, I don't necessarily feel the same way about some of the available earmarked money and the loans and for entertainers as I do the unemployment.
Yeah, and we're going to address it also later on in terms of the distinction between termination and furloughed employees. And, there isn't really any guidance from USCIS on, especially with furloughed employees. And we've been talking about this amongst ourselves as well. Yeah.
And I want to.
Right. I wanted to clarify also, my apologies, Fabricio, but just before I forget, there's a Q&A on the bottom, and if anybody has any questions, please put them in the Q&A, and I'll ask our panelists about those things either during the flow of the seminar, or there's a 15 to 20-minute question answer afterwards. So go ahead, Fabricio, my apologies.
No worries. I was just going to come back to tell you, we're going to be talking more about this issue later, I'm sure, but I think that this is an area where I'm talking to our colleagues here who are attending this seminar. This is an area where you need to seek advice individually, because there are different positions that different lawyers are taking, quite honestly, because we have no answer. This is one of those areas that we know, gray areas right now. There's a lot of uncertainty, and I think that is the best advice we can give you. But let's move on.
All
right. So I'm going to start by addressing some of the basics, immigration terminology. Then we're going to look at the various agencies that are involved with the immigration process. And in that section, we'll look at some of the COVID-specific rules that they have set up to help us through this period, as it were. From there, we'll go into the specific categories of visas. We're going to look at the B visas for tourists for business, then the O's and P's, which are going to be the ones that largely impact entertainment workers, and then we're going to look at some specific issues. So to get started with the basics, just to distinguish between immigrant visas and non-immigrant visas, as Robert said, it's the immigrant visas right now that appear to be on the chopping block, as it were, with this executive order. That is what you would typically know as a green card. It is a pathway to citizenship, wherein within 5 years or after 5 years of receiving the green card and assuming physical presence and continued residency, the immigrant visa holder would be eligible for citizenship. One of the issues that comes up often with immigrant visas is about taxes. Obviously, everyone needs to file their taxes. With respect to immigrant visa holders, it is based on worldwide income. And just to make sure that your clients are marking themselves as U.S. residents. I just had somebody come to me after 5 years on their green card, and they've been marking themselves as a non-resident, because they're also filing in Canada and receiving residuals from there, and that was the advice their tax person gave them. Make sure that they're talking to an immigration lawyer about that, because there are implications on our end as well.
Zoe, we always have this issue because the word resident for immigration purposes always means immigrant visa or green card to us, permanent resident.
Right.
There's a totally different definition for tax purposes, and that always causes confusion, I think, to your point.
Yeah, every different area has a different definition. We're going to look at agents later, and that's a different definition for entertainment lawyers than it is for us. The definition is different for sure, and it's just something to be mindful of, because now in this instance with this client, I was not willing to go with the citizenship application because I knew that question would be raised. And so he's now going to need to spend some time correcting that issue. But that's really all we're going to talk about in terms of immigrant visas right now, because our focus is going to be on the non-immigrant visas, which is, like I said, the B's, the O, the P visas, which is going to be the starting point for your clients. So we'll move on from that just to give you that distinction. Looking at the different government agencies. So under the purview of Department of Homeland Security, there are U.S. Citizenship and Immigration Services, Customs Border Protection, ICE. Then we're also dealing with Department of State when it comes to consular and embassy processing. And though we're not going to bring it up here, it doesn't impact O's and P's. Department of Labor does get involved with some immigration processes. So with regards to USCIS, this is the main agency we deal with. This is where we file the petitions for processing and for approval. Right now, in terms of COVID-related news, all in-person services are suspended through to May 4th. I don't know if there's any more recent information on that, but that's the most recent we have. They are continuing to perform mission-critical services, but all in-person, like biometrics appointments, stuff like that, have been suspended, and interviews have been suspended. They have also suspended premium processing. So traditionally, USCIS does provide the option for premium processing for an additional fee. Petitions, employment-based petitions, can be processed in 14 calendar days. Right now, that has been suspended. And just for context, with O's and P's, we're generally dealing with California and Vermont service centers. California regular processing right now is about 6 to 7 months, and I believe Vermont is 3 to 4, and they're basically split. Is that correctly? I see you going with this.
Vermont's been really funny lately. We've been getting things as quickly as a couple weeks that we've been filing recently. I think they're a lot closer to the 2 to 3 months. California,
California, they're the information on the website is pretty accurate in terms of October 2019 processing. We're just starting to get our October cases under regular processing in.
I wanted to add something. Go ahead, Robert.
Yeah, and for those people who don't practice immigration regularly, when would you submit a petition to Vermont versus California? Is there any, since the processing times are so out of whack between the two of them, are there situations where you could submit to either in Forum Shop?
Not Forum Shop, but the way it's split is basically by state. So half the states would go to Vermont, half the states would go to California. Typically, we're dealing with New York and LA with entertainment industry. New York cases would go to Vermont, and LA cases would go to the California Service Center.
The jurisdictional rules that apply are sometimes a little complicated. Sometimes you can choose one location or the other one. But I want to address one point that I have heard recently from production people. Everybody obviously is trying to go back to work. Everybody's trying to get ready. And the question that everybody's asking is, how long it's going to take? Now, the answer to that question in our world, in immigration practice, has always been, 3, 4, 5 weeks, because things take a while with immigration. Today, the answer, I think, is we don't know. It will take longer. Everybody needs to be ready for a longer waiting period. But here's what I think everybody is also considering. The best you can do for your clients right now, if you need to get them a work visa that you hope is going to be needed in the future, is get the case filed as soon as you can. Because it is true that we don't know if Vermont Service Center, California Service Center will bring back premium processing. But when that happens, it's going to be better for you if your case is already in the queue, because you can upgrade. So the best thing you can do for your clients is get the cases ready, get the cases filed, keep moving.
Thank you for that.
Yeah, and that's one of the things we're planning for right now is clients that we had calendared to work with for their renewals, for example. Maybe later on in the summer, we're now having to move up in our calendar to start processing now to make sure that there's no gaps in employment potentially.
So here's the great thing about O's and P's. You can file them up to a year in advance. So if anyone has a visa expiring through April of 2021, you can file that petition now and extend it if they're in the States, or counselor process it if it's out. I think it's the best advice we can give at this point, because as Fabrizio said, right now, how long is it taking? How long is a piece of string? We don't know.
Mhm.
Right. And unfortunately, that is going to be the answer to quite a bit of quite a bit of the questions right now, is we don't know, because we're figuring it out as it happens, real time. So, yeah. Where were we?
I think
Bring
we
and
were just
processing,
about
right. Okay, next slide. That's where we are. So that's just a summary of things going on with USCIS, Customs and Border Protection. I know we've all heard about the travel suspension. So any foreign national who has traveled to a list of 30 countries over the last 14 days prior to arriving to the US are banned from entry. Currently, the list includes essentially Western Europe, Scandinavian countries, the UK, China, and Iran. That's kind of a brief summary of that list. US citizens, legal permanent residents, and their immediate family members can still travel, but are subject to a 14-day quarantine period. And they can only enter from 13 airports, designated airports. In terms of restricted travel, there is restricted travel with Canada and Mexico, and it is limited to restricted non-essential travel. And non-essential travel, sorry, tongue-tied, is defined to mean tourists and recreational purposes. So people coming in for work are considered essential and should still be able to travel. We just had a director of international sales who traveled in from Canada just last week. So they are being permitted to cross the border. I
will say we hear reports of varying definitions of what is essential, and it might depend on the port of entry they're coming into.
Right, and that's one of the things, I mean, I'm definitely calling the ports of entry before a client comes in right now to make sure that there's not going to be an issue when they arrive. Yeah, so just make sure that they're aware of that. If they do need to travel, perhaps call ahead. So, you know, obviously we all realize, and DHS realizes, that some people might not be able to travel with flights just not existing right now. You know, for those people, obviously the best thing to do is to file a extension or a change of status in a timely manner before your I-94 departure date. And it is the I-94 that governs, not any information on the approval notice. And I think we discussed this in a bit more detail, defining what that distinction is later on. If they're not able to file in a timely manner for the change or extension of status, if the delay was due to extraordinary circumstances, they may permit the filing after that expiration date, as long as you can provide credible evidence of that circumstance. Of that extraordinary.
And Leah, can you comment on people on the ESTA program? That's mostly people from Western Europe who do not have to interview with an embassy to get a visa. They get 90 days. They apply online for those ESTAs. What about people who are expiring that are on ESTAs? What can they do, if anything?
So USCIS and the Department of Homeland Security have not given us a whole lot of direction on this, other than to say, we think this falls within our extraordinary circumstance that we already have out there, so we're going to let you use this satisfactory departure. So if someone's here, this is the most important thing as a takeaway. If you have clients who are here, you got to download their I-94 online. There's a website for CBP where you download that. There it tells you, and this is what dictates, not a visa, not an approval notice, nothing else. It's the I-94. If you see that they're here as a WT or WB, those are the ESTA categories. That means a visitor for business or a visitor for pleasure. And they have an expiration date coming up. You can contact the local port of entry that they came through, get a 30-day extension, but you can only do it 14 days before their time expires. So 2 weeks before their time expires, you get 30 days, and you can get another 30 days afterwards, is what we're hearing. They haven't done anything exceptional in this regard. You'll hear Canadians a lot, because these I-94s, and you may have seen them over the years, they used to be white or green slips in people's passports. Back in 2013, the government said, let's put this electronically. So now people have to go online to get that stamp to see how long you're allowed to be there. And if the government makes a mistake and you don't tell them and get it corrected, it's on you. So it's really important to do these I-94s, because we find a lot of time that people might be, they think they're here as an O1, they're actually here as a visitor. Canadians in particular were never issued I-94s before 2013 when they came up with this electronic system. And the problem is they're not used to having that date certain from which they must leave the United States. So that's just another reason it's important for you to go online, check if someone's in the country, and if their time is expiring, you've got to do something affirmatively. It's not just going to be okay on the other side.
Right. I want to mention too, and this is kind of colloquial evidence that I know a couple of practitioners who have submitted the day before the ESTA expires for that 30-day satisfactory departure, or the day of even, and had it granted. So that at least at a couple of at LAX and Dulles. So we do seem to be having some nice adjudications with those. Go ahead, Fabricio.
I was going to say that I'm glad to hear that, because even one day overstay can have serious consequences for your client. So the advice that Leah gave you that you should get the I-94s for your clients right now, make sure that nobody falls out of status, is more critical than ever. So keep an eye on that. Cool. Okay. The next slide here, we want to talk about I-9 compliance. U.S. Immigration and Customs Enforcement is another branch of the Department of Homeland Security. We call it ICE. And ICE is this organization, government entity that is in charge of enforcement of immigration law in the United States. And they are actually one of the main areas is compliance with I-9 rules. Now, as we all know, I-9s have been in the books for more than 30 years right now. Every person who's hired in the United States, no matter whether you're a U.S. citizen, green card holder, or foreign national, must complete a Form I-9. And there are very strict rules that follow and that you have to follow so that you don't have your clients facing an audit or a fine, or in some cases, actually even potential criminal liability for employing someone with that authorization. The issue here that we want to highlight is that you will think that when something like this happens, a pandemic, you will think that the government will be, a little more easy with these rules. The government gave us some flexibility, but the flexibility that we receive is not that great, actually, in my opinion. As you know, when someone is completing a Form I-9, a requirement is that someone has to physically examine the documents being presented to make sure that the documents relate to the person who's showing them to you, and that the documentation actually is acceptable. Now, that review of the documents have to be done in person. For many years, immigration, we have been asking immigration, ICE, to allow us to do that verification virtually, like I'm doing right now with you. If I show you my passport, you can see that it's mine. And ICE has consistently said no to that. Finally, now, they are allowing some of that, but still there's some requirements that you have to satisfy that make it not that simple. I think that right now, the best thing that you can do in these cases sometimes is continue to use agents or individuals to review I-9s on behalf of employers. I think that is the safest way to do it right now to satisfy the I-9 rules. I think that all experts agree that at some point, companies will have to respond to, situations that happened during the pandemic. And another advice that we have is that you have to document all your efforts and everything that you did to satisfy these rules. Leah, you want to go ahead?
I'm going to put this all together for you. We're throwing a lot of terms around. There's USCIS, there's CBP, there's DOS, there's DOL. Really quickly, this is how it works. One, we file a petition with USCIS. Citizenship and Immigration Services, they're the ones who grant the petition. Once that petition is approved, then everybody, with the exception of Canadians, has to go to an embassy or a consulate outside the United States and apply for their O or P visa. That's not the end of it. You can't just realize, oh, great, the petition's approved. No, they still have to get a visa. Right now, all of those routine visa services have been suspended. And those, it's not just a rubber stamp anymore. It used to be, but now you have to be really careful and have your clients prepared for this if they haven't had O's and P's in the past. You see somebody behind bulletproof glass. It's a very unnerving for especially some of the newer artists or younger ones. And the first question they come up and they say, well, why are you so great? Our best advice to clients is put on your Donald Trump hat and say, I'm so great because I do this and that and the other, and list out 3 things. Don't be unnerved by those questions. Listen to the questions, but it's not just done at once the petition's approved. Then they go to the DOS, Department of State, to get that visa sent in. That usually takes a good week on a good day. You really have to plan in a week. So it's, when Fabrizio said before, it takes about 4 or 5 weeks pre-COVID, you got to figure it's a week for the consultations, 2 weeks for the immigration, another week for the embassy. And that's where we come up with that, 3 to 5 week sort of window. But again, that's if everything goes right.
Okay, so going back to the purpose of today's seminar was to talk about some specific visas that are applicable to the field of entertainment. Before we get into those specific visas, which are listed here, obviously there are way more visa classifications available. I think the big picture for you guys to take out of this is that you have, obviously you have US citizens coming to the United States, you have green card holders, and then you have foreign nationals, and they are coming in a variety of different visas. One way to tell when you are dealing with a non-immigrant visa is that they are named with letters, which correspond to the sections of the regulations and the INA. So here are the examples of visas that are very applicable to our area, and we're going to be talking about all of those today. So let's start with one of my favorite topics. I think this is a very important one for entertainment lawyers to keep in mind. So here's the question. When a foreign national comes to the United States, what activities can that individual perform that are permissible as a visitor for business? And the reason why that distinction is so important is because if the answer to the question, can this person do this or that as a visitor for business, that means that you don't have to get that person a work visa. If on the other hand, you conclude that the activity happening in the United States is an activity that actually requires a work visa, then you have to go through the process that Leia and Zoe were describing, which is going to take several weeks or even longer right now. So that is a very important question. Now, the big picture here is that a visitor for business may not engage in what is considered local employment. And the concept of local employment is a really kind of confusing sometimes concept. The guidance that we have is coming from a case that is probably by now over 50 years old. It's called Matter of Hira, if you want to Google that and read it. It's a case involving a suit maker that was coming to the United States to take measurements of the clients. And that is the guidance that we have. That in addition to the Foreign Affairs Manual, some regulations and some practices that we learn. So examples here that we want to talk to you about because they are very applicable to entertainment include the following. What about a job interview? If someone is coming to the United States to be interviewed, is that permissible as a visitor for business? The answer is yes. What about an audition? If you have a client of yours who's coming to attend a casting session and the person is going to be watched by the casting director, is that going to be considered local employment? The answer is no. I think my colleagues probably also agree with that. What about coming here to attend business meetings? Again, it's something that is permissible. Conferences, the same. And then the next one is something that I'm sure Laia will not talk about that because that is her specialty, talking about prize money and also the showcasing. Laia?
So there's pitfalls. You don't want to, if you can use a work permit and you have the time, it's always great because then the decision is already made, the person comes in, there's not going to be any problem. When you use the B visa, it doesn't have that petition process. So the decision lies with that Customs and Border Protection. I guess I should have mentioned that's the third thing, is when somebody comes into the United States, presents their visa, or in the case of Canadians, their approval notice, and says, hi, I'm here. And then that CBP issues the I-94 departure record. So when you're here as a visitor, like Fabrizio said, anything, it's business meetings, conferences, basics, competing for prize money. So if you have a lot of sporting people, like a golf prize, you can't do it though if there's a guaranteed purse, like there is in boxing. So it doesn't work the same. That's why it's always better to err on the side of getting the work permit. Similarly, showcasing, I get this one a lot. So if they are truly doing a showcase and it's in a closed environment with invited guests only, no remuneration, and you're not paying the band, that's a permissible B1 activity. But if they get to the border and the local CBP officer Googles to see about this band, and then they see that, oh, there's a cover charge of $2 for their showcase, that's it. They need a work permit. Flies to the other side. So you really got to be careful with that one.
It's fascinating. In fact, one more thing for you, our colleagues, to be aware of. There's this note in the Foreign Affairs Manual that is actually specific to entertainers. And it says basically that if you are a professional entertainer, you are not allowed to come to the United States as a visitor for business to perform activities that are local employment, even if you are not paid.
Okay, so what happens is when you come in under, I forgot where I left off. Anyway, payment, the source of payment. A lot of people want to come in and say, well, I'm not getting paid in the US. It doesn't matter. If you're engaging in meaningful employment for which you would normally get paid, you're just getting paid outside the United States. It doesn't work that way. It's not a workaround.
Yeah, and I think a lot of people is that simply if they're not getting paid, that's the end of the story. I don't think because a lot of people come to the office and say, well, I'm not going to get paid, but I don't think they realize the flip side of that, the audience can't be paying.
So I have a question either for Zoe or Leah. What about a reality show where they aren't getting paid, but if they win, they will receive prize money? I have seen it go both ways. Is there anything specific that you would recommend to be presented to the CBP officer to support coming in on a B1, B2 instead of an artist visa?
When it's a true reality competition show, the B1 is a perfectly acceptable visa. The magicians who are not actually professional magicians, but they're trying to compete for a show in Vegas, right? Once they get the show in Vegas, they're going to need a O visa or a P visa. But if they're just coming in for the competition and there's only prize money, or you can also be reimbursed for incidental expenses like hotels, airfare, stuff like that, that's all good under a B visa. But once you get into some of these reality shows where they follow the people around and they get paid for that, no, that absolutely needs a work permit.
Thank you.
So you can't see it, but we would have, next would be a slide about going through this O and P sort of procedure. And Zoe's gonna give you the quick rundown on that.
Yeah, and Leah, you covered it earlier when you were giving the nice summary of the different agencies that we deal with. But basically, just to recap, the petitioner sponsor, which is either going to be an agency or a direct employer, they'll file a petition on behalf of the beneficiary, who is the employee, your international client. As part of the petition, the beneficiary will need to secure consultations from the appropriate guild, union, or peer group, so actors from SAG-AFTRA, directors from DGA, so on. And in the case of motion picture television, we would also need a management consultation, which is a different additional requirement for that category of artist. And Fabrizio is back.
I'm sorry, I'm back right now. My technology failed me today, but sorry about that.
Usually it's my technology that fails us.
Let me bring the presentation back to the screen and you guys can continue. Give me a second. Okay, here we go. Back in business.
Yeah, so we were just going over the
Consultation.
procedure. And right now, the guilds, they're all pretty much set up remotely. And, we were talking about, we're actually getting faster consultations now than we ever did before the shutdown. So things are moving pretty much uninterrupted there, it seems. So from there, submit to USCIS, where through one of three things will happen: an approval, denial, or more often than not, a request for evidence, which allows us the opportunity to cure any deficiencies with the application. And just this process is not simply for O's or P's. As Fabrizio was mentioning earlier, there are a lot of different visa non-immigrant employment categories, and this procedure will apply essentially to all of them. And so USCIS request for evidence, there isn't really a hard or fast rule of what that could look like. Each one is different. We're going to address some common RFE questions that come up later on, but there really isn't any hard and fast rule or what those look like.
Everybody gets them. It happens all the time.
All the time.
There's a lot of training issues with the immigration. We see trends, we jump on them, but we don't even have the same level of discussion with the immigration. So your clients are going to get requests for evidence. I think nationally it's up to over, 50 or 60%. More seasoned attorneys don't see that many, but I think there's a good 1 in 3 chance that if there's a deficiency or something they perceive as a deficiency, that the immigration is going to give you a chance to cure it. But it is going to screw with your timeline on some of these tight cases.
Yeah, absolutely. And then once the petition is approved, it will go to consular processing. And like Leah said earlier, just because you have an approval notice from USCIS, that's not the end of the matter. They will also review the entire petition at the in-person interview at the consular phase.
Somebody had a question that said the difference between an extension and just filing a new petition. And we get this question a lot recently in particular. The word extension it's a term of art in immigration. It's which box we check. Fabrizio, by the way, do you know we have a weird ass screen up there? It's not the slide.
It's not the slide, I'm sorry.
That's okay.
It's not the president.
What happens when you file an extension, you just tick a different box. And the extension means they're in the United States. And once they go out of the United States, they have to go pick up a visa to come back in. So the visa only has to be valid to come into the States. Knock on the door and say, I'm here, I want to be admitted. The I-94, what we discussed before, dictates how long you're allowed to stay in what status. Once you're here, you can change your status, you can extend your status, but that extension is just a term of art in immigration that only says, okay, we're in the US and we want more time. The petition work is literally the same.
Yeah. So the procedures, like I said, apply to all non-immigrant visa categories. Looking specifically at the O visas, I think it's the next one, Fabrizio.
Sorry, there you go.
No, don't worry about it. So looking at O visas specifically, there are 3 types of O visas, and each one has its own standard of evidence, standard of proof requirement. The O1A for extraordinary ability, science, education, business, athletics. O1B in arts, and then O1B for extraordinary achievement in motion picture and television. And the standard varies from sustained national or international acclaim to distinction. And each one, like I said, there's 3 different standards there. Really the takeaway here is you can't come to the United States to become extraordinary. You have to have achieved extraordinary status prior to coming. The way the criteria are worded is has and will work for distinguished organization. So it's not just a matter of what you will be doing, working on that HBO show. It's also what you have done in the past. We'll use a variety of things to evidence that, from press and reviews to nominations, awards, letters from experts in the field, and so on. So that's really the main takeaway here, is that they already need to have achieved that standard of excellence prior to applying.
One common misconception that I hear a lot of times is that people say, oh, I can make an O1 case based on letters of support. That is not true. The letters of support are a very critical element of the evidence, but without actual evidence of achievement and recognition in the field, you just cannot get an O1. And also, the thing I want to point out is that immigration has, they are reading these rules and they are applying the rules strictly. If the rule says that you have to have achieved recognition based on work on productions, plural, that's what they mean. They're going to come back to you. If you file a case and you claim the person was very successful working in one production, they're going to come back and say, well, the regulation says productions. Where is the other one? And you may lose a case that way.
Right, and with some of the criteria, letters of support are not even an acceptable form of evidence for some of the criteria. They're limited in their use.
Yeah, sometimes when I explain this concept to clients, I say, this is the visa for those who already made it to the top, not for those who are on the way. So that's that. Now, the O2 visa classification here that we want to talk about is a really good tool to consider in some cases. Applies only to artists and athletes. And the idea here is that you may have someone who is an O1. I mean, O2 visas are not standalone visas. You have to attach an O2 to an O1. And the O2 purpose is to provide essential support to the work of the O1. So, for example, you're bringing an actor, and the actor needs to have this person who does his hair because it's so critical to the production. And that happens once in a while. That would be an example of an O2. Now, the interesting thing is that the O2 visa in the field of motion pictures and television, there's actually a rule that allows to make the case for an O2 based on continuity. And that is a really important tool to keep in mind. So let's say you have a production happening out of the country and the production already started. And the actor and some other members of the crew have been established already during production. If that production now comes to the United States, then you may be able to attach support personnel to the O1 and get visas for all of them. So that is a really good tool to consider, those of you who are lawyers practicing with productions. And I think this is a type of situation where you're making sure that you bring your immigration counsel early in the production is going to make a significant difference, because immigration lawyer who's involved earlier can help you, plan so that you will be able to satisfy these requirements. So that's a good thing to keep in mind. So the other thing here that I want to mention to you is that there have been an increase on questioning on these cases. Leia, I think you have some examples of that to share.
Yeah, so we've got motion picture and television where you're going to have one thing I just want to clarify. The O2 has to be attached to the O1, and the O1 has to be a foreign national, because I get that question a lot. They're like, oh, but I have this US citizen, but they want to bring in their personal assistant from Europe. You can't attach an O2 to a it has to be a foreign national. It can't be an American or green card holder for that matter. So you think about it, you've got the director, and then you might do the DP and everybody else under that. There's no limitation on how many O2s you can put on a petition. In the music industry, we use, it could be an O1 is the lead singer, and then the O2s might be the backup singers, the backup dancers, the tour managers, light, sound, stage, depends on how big it is. But they all have to have had critical skills with the O1 already. So you might have to have multiple O1s, which is what we've started to do on a lot of these bigger music productions, where we put the caterers on one, we put the stage crew on another, because you have to match up the critical skills. Immigrations come back really hard on these. And they don't just want a letter from the O1 saying, yeah, I've worked with this person before. They want independent corroborating proof to show that the O2s have previously worked for the O1s. What that is, the immigration spells out as photos or travel itineraries, invoices showing that they have been paid by the same entity, or that maybe the O2s are paid by a different entity, things like that. Tour books are great, call sheets are great, anything to show that there is that prior existing relationship. There's no set time it has to be. And the immigration, I've had tours, maybe they were in Europe for 3 months first, and then they came over and you wanted to bring the whole crew, that core crew over, and they say, well, no, they've only been with them for 3 months. And then we come back to them and explain 3 months on the road is not a 9-to-5 job, 3 months in an office. Totally different things. You're comparing apples to oranges. So the more information you can give people to prepare for these kind of events. Similarly in sports. So when you have an O1 athlete, you're going to have O2 essential support personnel and the trainers and the coaches and anything really. O2s are really good. Especially the other one that comes up a lot is you'll have an O1 who is a child actor or a child musician. It's always good to put one of the parents on as an O2, as a manager or a personal assistant, and then that parent can bring the other spouse and children. So there are ways to do that, and I think they're very valuable.
Yeah, the interesting thing also is that we noticed, I think starting last year, some embassies, particularly London, started to require that the O1 visa be issued first before the O2 visas were issued. That is something that is kind of new. I think it makes logical sense, but it's something that I haven't seen in many years.
I don't think it makes a lot of sense
sure.
at all, because you're going to, and in fact, the field guidance says the O2 can come in before the O1 because, you think the O2 has to come in and prepare for the O1. So to come over. So you might need them to build the stage before the O1 needs to be over for rehearsals. So that rule that just came into effect in the last couple of years in London is not being applied to everything. But yeah, that's more, I guess part of the takeaway we want to give to you is the more advanced notice, like the second something's being discussed, immigration should be there too. That's why, even though it seems like nothing's really busy now and we're all kind of taking this step back and looking at things, we have a year to file these in advance. Do it now, because we don't know what it's going to turn out. The embassies might end up taking 2 weeks or 3 weeks because now they're going to schedule, Zoom appointments to talk to people. We don't know what's going to happen. So I think it's just important to do everything as early as you can.
All right, thank you. Okay, so this is your area, Leah. Go ahead.
Oh, well, so similarly to an O1, O2, there's also the P1 and P1S or P2. There's different categories. It used to be the H's back in the day, and in the 1990s, 1991 is when the O's and P's came out. So the O's were looking at the individual and then attaching O2s. The P1 was to look at groups. Now they also put the athletes in there. So if you have an individual athlete they can get a P1 visa, and those are nice because they're actually 5 years, where the O1, O2s are limited to 3. Now, if you look at an entertainment group, like a dance group, a musical group, and or an athletic team, then you do what's called the P1. Now, when you get to the P1 group, that group has 75% of them have to be performing together for 1 year. So a lot of times we'll get newer groups that are put together where you can't do a P1 because they haven't, and it's 1 year from the time they could have started anything. So it could have been like the first day they recorded, not necessarily the first piece of press they have. So if you have the record contract showing that they were together for a year, that'll work. But if you can't make that year, you might want to think of O1, O2s instead. But, these are kind of just talking points that there might be other options than just O or P. The nice thing about the P is that you can substitute beneficiaries without having to file a new petition. So if you think about circuses, which has its own, you don't need that 75%, but where people get hurt, shows where people get hurt a lot and they need to bring somebody in really quick, or orchestras where you thought you had this violin player, but you got to bring in another violin player instead. So those are the nice things about Ps. So you got to think about all these considerations when you decide which one to pick.
One more thing that I always mention when I explain this to clients is that another advantage of the O2 visa and the P visa that you can use for multiple people is that you can save a lot of money on filing fees. Because you can file an O1 petition for 50 people and the filing fee is going to be the same, one filing fee, the same one for a P visa for a group. So that's another very good thing to keep in mind. Now, talking about options, another option I want to mention to you is these additional sub-classifications of the P visa. One of those is called the Reciprocal Exchange Program. There are several programs that are recognized by immigration that based on those programs, an individual could work in the United States. There are a couple more that are not applicable to entertainment, but the ones that you really want to keep in mind are the American Federation of Musicians. They have an AFM program that allows Canadian musicians to come to the United States to work. Those cases are handled directly by the AFM. So you can contact the AFM if you have a client who's Canadian musician, and they will help you with that. The other one that I want to mention here is that there's actually a reciprocal exchange agreement between the Actors Equity that represents theater performers from the United Kingdom. So if you have a client who is a theater performer, who's a member of that union and is coming to work in the United States for the sister organization, that will be another option to consider, a P2 visa for them. And finally, the other one in entertainment is there's actually a reciprocal exchange agreement between SAG-AFTRA and the sister organization in Canada that represents performers, actors, motion pictures and television actors. The nice thing of the P2 visa is that if you can get a case under that classification, you don't have to show that the individual is an individual of extraordinary achievement. So the evidence required for this P2 case is less than what you will need for an O1 visa.
Literally, they just need to be a member of the unions involved. Yeah. And, it's the cost of a Canadian Federation of Musicians fee, and you have to have work to do in the US. They're very easy petitions.
That's very beautiful. The P3 is another one that is interesting for those of you who represent clients who may be culturally unique performers. Some people are coming to the country to showcase the culture from their countries. That's another example of the use of the P3 visa. I also hear, Leah, you have used that visa for some bands that are very traditional and all that.
Yeah, they're really great for when you can't make again, our immigration is a slot system. So it's always important to bring the immigration attorney in early, because it might be a B or it might be a P, or it could be a P3 because maybe you don't have the 1 year requirement, but they're super well known in an African dance that no one's ever heard of before. And then you don't need that 75%. You don't need the international recognition. What you really need is a letter from an expert in that field. So what you do is you go to some local whatever university you can find who knows about this dance, and they write the letter. It's a great category. And I think Fabrizio teaches there's actually a case, one of the few cases again, because the thing with immigration, we don't have case law, because if you don't win, you can't appeal it. It takes too long. So you just refile it or repackage it or recategorize it. Maybe you did a P and now you're going to do an O1, O2. So here's one that we actually do have.
Yeah, it's a Skirball case, isn't it? That's the one you have in mind?
Yeah.
Yeah, that's a fascinating one. If you guys have time to read that case, Skirball, that's is the museum or something here in the 405 freeway. Is that right?
Yeah.
So that's a case where it's a really useful case because it basically explains how to be considered culturally unique. Immigration was taking a strict position that you have to be culturally unique from only one culture. And Skirball basically explains that you could have a combination of cultures and also highlights the importance of giving deference to letters of support from experts. So it's a really useful case. Yeah, excellent. Leo, do you want to talk about the essential support personnel for P2s? I think we kind of talked about that.
Yeah, really,
P1s.
really quickly. Just like how you have the support personnel for the O1, like let's say you have an entertainment group, you're going to call anybody who's not on stage crew. So, and you file that on a P1S, whether it's the tour managers, sound engineers, all that goes into the P1S, or any of the other, let's say we have a sports team, the coaching, the training, anything like that. Again, P1S support.
Perfect. I think we're moving now to this interesting concept of who can file the petition. And this is going to be very, very interesting to our audience as they represent productions and actors. Would you like to start? Zoe, would you like to start with that?
Sure. So who can file a petition? So there's two basic ways in which a O or P petition is filed. It's either directly through an employer, so the production company or the production itself would act as the petitioner, or it would be an agent petitioner, which is, not, as we were saying earlier, the traditional definition of agent in the entertainment context, but really somebody who's agreeing to serve, agreeing to act in the place of the employer is really the definition of it.
Think of your agency partnership law.
What's that?
Remember agency partnership? It's an agent,
Right.
little a, not the big A's as in WME or CA,
Right. So, the artist has multiple projects lined up over the course of the 3 years expected for the visa. So the agent will act as the individual petitioner on behalf of all of those employers is really the concept behind it.
Under the regulations, the agent can serve three purposes. And they can be, you can file a petition that actually covers the three of sub-classifications in one petition. But my point to you, colleagues, is if you are having your immigration lawyer prepare one of these petitions, make sure that they are clear about the intent and express that in the petition. The three elements, the three possible uses are if the agent will serve as the employer. I don't see that useful for entertainment, motion pictures, and television, because if the employer and the agent are the same, that means that the beneficiary can only work for the agent. So I know that type of arrangement is usually used in the context of models for some reason. I think it's traditionally, historically, how they do it. The second one is the one that is really useful, agent for multiple employers. That would be a case where an agent, which as Leia said, it doesn't have to be an agency company, it can be a representative, files a petition with immigration telling the service, I am filing this petition, and based on this petition that you will approve, my beneficiary will be able to work for multiple employers, including me, for example. So that would be the second example here. And the third one is another one that is interesting for you producer lawyers, is the one agent for a foreign employer. And the reason we have that is because under US regulations, only a US person, employer, can file the O1 petition. So let me give you an example. Let's say that you're working with a production that is happening in New Zealand, and you have a production company there that usually is going to be a New Zealand company because of tax reasons. The crew and the actor, directors, above the line people, they are being employed and engaged and paid by the New Zealand company. Let's say that production now comes to the United States, and now you need to get visas for these people. That would be a case where that visa petition will have to be filed by a US individual or employer acting as an agent on behalf of the foreign employer. And they have to be explained in the petition. The agent filing the petition has to agree to receive service of process in the United States. And and that is what you have to do. So be clear about what your intent is. The other thing I can share with you is that there are some studios that are not accepting agency petitions for some reasons, but a lot of studios are accepting those. And I think that in these times of the pandemic, having an agency petition is actually a great advantage, because that means that you may have a client who has a pre-approved petition that allows him or her to work immediately. And if that petition is properly prepared, and the studio accepts that, your client can begin to work right away. And I think that what's going to happen now, at least, I'm hopeful that when things come back to normal, production is going to ramp up. And everybody will want to have everybody ready to work right away. So if you have an agency approval, that will allow your client to do that.
Right.
I don't know, Zoe or Laya, do you want to talk about loan-out companies? I think you have some examples of that.
Can I just make one practical point there? In the case of studios who insist on having their own petitions filed and want to have their own O visa specific to the production, just to be clear, a beneficiary can have more than one O visa. So if you've already filed an agency petition for them and they've been approved, they can also have the second O visa with the specific production or the specific studio. So one would not conflict with the other.
So just to kind of big picture that, you can have as many different approval notices as you want. You could have an O1 for Paramount approved. You might have an O1 for your loan out company, and then maybe CAA filed an O1. You can only have one O1 visa stamped into your passport, but the passport visa O1 is not specific. You have to have the underlying petition, which is what you're coming in to work on. So whether it's the movie for the studio or maybe something you're doing through your loan out, but that visa is still good, even if the name on the visa is different, if you have enough different underlying petition. So there's the petition, the visa, the I-94, they all interconnect and mean different things. Really quickly on loan out companies, some people don't like them because there's a word called self-petition, which you're not allowed to do as an O1. That being said, you could be an O1 actor, musician, or a P1 group that own the petitioner or the sponsor, but because it's a separate legal entity, the immigration allows you to do that. You have to disclose that on the I-129, which is the form you file for the O or P visa, but it is absolutely allowed.
Before we move to the next contracts and itinerary discussion, I want to point out to you colleagues, to the checklist that you're probably writing down now. What should I call my client and ask for? The I-94 we told you. The other one, good point, Leia. Get your clients to send you a copy of their visas, so you know the expiration of the visa. Because when time comes for a studio or an agent or your immigration lawyer to work on that case for your client, those are the pieces of information that we need to know right away. Because once I know that, I can tell you what the options are. So the I-94, the visa, get a scan of that and have it on your records so you can share that with the lawyer working on your case.
Because it's all about timing, right? So if you need someone on the set right away and they already have the O1 petition under their loan out, let's say, they have the O1 visa, you've skipped a good chunk of that 3 to 5 weeks, which is still a little short, but it might make the difference of your client being able to be cast or not. I've seen that many, many times. Once you have the O1 visa, it might really help your client in the future. Because the whole big thing, and we're getting into contracts and itineraries, but you have to put something into the petition to begin with, what they intend to do. You can't just have random information that they may do in the United States. But if it changes during that 3 or 1 year term, that's okay. So that's where it's all kind of a little tricky, but also helpful. And that's what the immigration regulations were really set up to do, was understand that these people might say they're going to do X, Y, Z. And especially in COVID, it's actually going to be X, Y, Z, but 3 months in the future. That's okay.
I had a question about agency. What if the beneficiary has one job offer from a U.S. production company and another from a foreign company that will be shooting in the U.S.? What type of, quote, agent would this be? Agent for multiple employers or agent for repping the foreign employer? Or would you file 2 separate O1 petitions?
I will suggest for that one, I will file an agency petition that actually explains that is filed for the purpose of allowing the beneficiary to work for multiple employers and also to serve as the agent representative of the foreign company. I don't see any problem with combining those two if there's one petitioner. Do you guys agree with that?
Yeah.
And I had another question, which is, why do some studios want project-specific visas?
I don't have a good answer for that because
Yep,
I believe that they just, I don't know. Do you guys have any input on that?
There's an interplay between two regulations. I know this is hard to believe in these government times, but they can directly conflict with each other. One says that you can change and the work as long as you still need an O1. The one above it says if it's new employment, you need to file an amended petition. So those kind of I know why they were developed that way, but they don't explain it. And you've got to realize nobody who was around in 1991 when these immigration rules were put into place, including the immigration officers, the unions, a lot of those people are not there anymore. So it's a conservative approach that I don't necessarily disagree with if I'm on the side of the studio.
Yeah, I want to point out before we move to the next topic, regarding the contracts and itineraries. The challenge is that immigration takes the position that the employment that it serves at the basis of the O1 has to be non-speculative. And that is a very, vague concept in some way, particularly when you're dealing with productions. Like I can see a contract for someone, let's say you have a pilot contract, and then you have an options that will be exercised if the pilot is picked up. Now, from the perspective of the production company and you contract lawyers, you probably are looking at the option as a situation that is non-speculative, because even though the option hasn't been exercised yet, it is very likely that if the pilot is picked up, you're going to be able to exercise the option. So that is some of the things that we as immigration lawyers sometimes have to balance. And sometimes I may have to advise my client, let's file a petition that only covers the pilot. And in some cases, I may advise to file a petition that covers even if the option is exercised. So this is an area that is kind of an influx right now. Immigration is a little, it's not clear. What are your thoughts on that, Leigh and Zoe?
I mean, we will file petition with options built in for second and third seasons, and with that, I don't treat as speculative, really. And
let me give you a little context with that. The whole idea is you can't come in here just to freelance. We don't have okay, here's your work permit, go be a movie star. You have to have an actual production you're going to work on. The unions require it. The immigration requires it to a lesser degree, but you have to have actual work. So in motion picture and television, they want a signed deal memo from a production company from the get. If you're doing music, you have a little bit more flexibility because you've got a recording contract or a publishing deal or some dates, so you have stuff to interchange. The whole idea is you need to have something to do. So the important thing is to develop what are they going to do in the United States. You can't just come here and hope that you can work as soon as you get picked on an audition. It doesn't work that way.
Yeah.
And we need to move on a little bit.
Yep, thank you. Okay, so I think we kind of talked a little bit about this earlier when we were at the opening. I mean, the situation right now, when an O1 beneficiary is no longer working, and I think, Laia, your position is that there's a period that begins once the person is no longer working. That's the conversation that we had at the beginning?
Right. So the idea is let's say you have an O1 with a 3-year contract, or 3-year visa, and they're here in the United States 3 years. If there is a material change in the terms and conditions, you have to file a new petition. That's where the change of employer comes in. Some studios want it, some don't. Amended petition, they specifically say that just adding another engagement or performance does not require that amended petition. But let's say now it's not a loan out company, but it's a motion picture and television one based with the studio, and you and the studio get in a fight. And the studio says, we're not going to use your O1 anymore. And they write to immigration and say, we're not using their O1 anymore. We're terminating and wish to withdraw this application and petition. then that person's going to get 60 days from the date of termination and to either file a new petition or leave the United States. It's no longer just that date that they had that might be the 3 years out.
Got it. I think another situation where this is interesting now to look at is what happens if you have an O1 person who is furloughed and the person continues to receive benefits, let's say, but the person is not being, is not getting payment because there's no work right now. The question then is, the 60-day grace period, does that begin when the person is furloughed or when the person is let go if that happens in the future? I mean, you guys have some thoughts on that right now?
I mean, there's no real guidance, but my take on it is that it starts when they're terminated. I mean, we've got clients right now who are furloughed for 2 to 3 weeks, but they can't go work for anyone else. They can't, there's no opportunity for replacing one job or one contract with another contract or anything of that nature. So they're still employed by that company or that project. And the expectation is that they're going to start working again in 2 to 3 weeks. There is no termination there.
Yeah, thank you. The other area that is gray area right now is the situation with receipt of unemployment benefits. And I heard you, Leah, talking about that earlier. I think it's interesting, and unfortunately, there's not really a good answer because the federal government has expressed that benefits received through the CARES Act are not going to impact this concept of public charge because those are earned benefits. In other words, basically the federal government is saying, if you choose to take this money, we are not going to hold that against you as an indication that you will become a public charge because the money that you're getting is basically what you contributed and your employer contributed. That is what we hear from the federal government. But then the problem is that the administration of the unemployment benefits is done through state law. So the challenge then is that you have to look at the individual requirements on each state to determine whether your client will be eligible for that. And that requires some analysis from an employment perspective that is beyond immigration. And I think the second point is, depending on the language on the specific state law, you may now be concerned about some public charge concerns. So it's a really complex issue. I don't know that we have a straight answer on that. Do you guys agree?
Yeah, I think the problem with the unemployment by the state is it's not earmarked as part of COVID. And so I think that's where it gets into trouble. But I understand they're trying to make it more available to people. I don't have a good answer. You're right.
I agree. Excellent. Let's move on. Let's see what else we have. Inadmissibility and waivers.
Oh, this was this was mine. Occupational hazard. It's really critical to have a transparent relationship with your client. Please ask them, and if they don't feel comfortable talking to you, talk to their immigration attorney about any arrest, cautions, pardons, expungements, anytime they've been in handcuffed or fingerprinted. All those things matter for U.S. and some other countries' immigration. So if they are honest, it comes out so much better. Just really hammer and ask them everything about that.
And the U.S. immigration does not, even if there's a pardon in another country, they don't take that into consideration. You have to report on all of it.
Yeah, I think you have some notes on the use of marijuana in the context of immigration.
So, just like unemployment, marijuana, it's state by state right now, and there's 30 to 33 states that have some kind of rule on the books, whether it's full recreational or just medical marijuana usage. But it's still an illegal substance. So for immigration law purposes, anything related to marijuana is still considered a basis for inadmissibility. And one of the things that they're doing right now, they do it at customs and they'll do it at interviews, is they are doing social media searches. So, my client who was posting on Instagram saying, on my way to Vegas, just had an edible, they're in trouble now.
I had the vape cartridge at LAX. Well, it's legal in California,
Right.
not so much. They forgot to change out the one with the THC, or is it TCH?
Right.
I'm confused. With the other one, I'm so bad. But marijuana is such a huge problem for the US. It is not legal federally, therefore it is not available for your, it causes a problem. People with medical marijuana licenses, when you go to the medical marijuana place, they're actually required to report those names to the federal government of who buys them, and it will come back to bite your clients in the butt. I have one who went to go get his O1 renewed for the 5th time. They Googled him. They found out he was on the board of a company that distributed marijuana, and he was charged as a trafficker.
Yeah, and the other thing, it's not just usage that is an issue. They are trying to make connections with, if you were in a commercial for a marijuana company, or on the board, like you said, they are trying to make those connections right now.
And the other thing that's important for immigration purposes, not only do those pardons and expungements don't count, but you don't actually have to have a conviction. You could admit the essential elements of the crime to a consular officer or an immigration officer, and it counts just as much as a conviction. So in the case of the guy with the vape pen who had the wrong cartridge, they said, "Is that marijuana?" He says, "Yes." "Did you have it on your person?" "Yes." Done. It's like he's been convicted of possession of marijuana, requires a waiver from here on out.
Well, we have about a minute or so, and then we've got to wrap it up and go to the questions. So just to let you guys know.
Just so you know, if you need a waiver, you could add up to 6 months to a year to that whole lovely 3 to 5 week thing that we're trying to push. That would be the bare minimum. Any kind of marijuana thing, any kind of drugs, any kind of those things there, you've really got to be conscious of.
So we have some questions. One of them is, we have a client who has an O1 that expires May 3rd. The end date determined by an event he was contracted for. The event has now moved to December with the potential shift again to May of 2021. We were already in the process of filing a new visa. Should we just follow through with the new visa, or should we try to revise this existing one?
If the visa expires, wouldn't they need to apply for a new one? Sorry, did I miss the fact?
Yeah, it expires May 2nd. So, seems to me something has to be.
Are they in the United States or not is the question. If they're not in the US, then it depends where you are. Did you get to the immigration? Because once you get to the immigration and you've requested that time, as it stands now, you can't change those dates. You can't say, okay, can you now make it this? There's no mechanism for that as it stands now. Maybe that changes, we don't know. But if you've already filed the petition and have the approval dates, the validity dates of that petition stand. You can't change them. So it just you need more facts.
Yeah,
Okay.
And strategically, you're gonna have to decide whether you either gonna extend, and you can only extend what is still valid. So if that is the decision, they have to file that extension before the expiration, or choose to file a new petition that will trigger need for new documents in some cases. So it's a strategic decision that the lawyer will have to decide.
I have another question. If you have an actor under an O1 with optional series years, and the studio does not pick up the actor such that there is time left on the visa, is the studio obligated to report back to the feds?
Yes.
I heard two positions on that. I guess you take the position that you have to notify immigration.
That's what regulations say. Whether or not they do, that's different. But yeah, regulations say you're required to report a material change, and I think not using them is a material change.
Very good.
But the distinction I have heard also is that O1 visas are not exactly, there's some visa classifications where the withdrawal of the petition is necessary, because if you don't withdraw the petition, you are liable for the salary of the person. Those are H1Bs, for those of you who practice in that area. O1 visas don't have that. So there's less incentive from the employer perspective to notify immigration, because really there's no...
Was it an agent petition and the studio was just used as a basis of the work, in which case I don't think so.
Correct. That will be another point.
Yeah, you know
Right.
what I'm saying?
Depends
Yeah.
on who petitioned.
Yeah.
Any other
Which
questions?
is sorry to interrupt you, but that
Go
is
ahead.
actually one more. So that is actually one more reason when having an agency petition is an advantage.
Agree.
Any other questions that people want to type in the Q&A? We have about 10 minutes left theoretically. Any comments from the panelists? It looks like we've done all the questions either during or after. So any other thoughts about this crisis or about any timely issues that you think our audience might have an interest in?
Not about the crisis. I made a note to myself earlier on one of the slides. One thing to note also is about hyphenates. So writer-directors, writer-producers, you can apply for both on one petition. So you get a consultation from the PGA and the WGA if they have work in both areas, and you submit it as one petition. That was just something I wanted to mention.
Yeah, same with
Good point.
a director and a producer.
Right.
You don't need to file separate petitions for all of those. The other thing I was gonna, and Zoe can expand on this, but going into Canada, we know this is a US panel, but it is so close and yet so different. Drinking and driving is an indictable offense for Canada, and it absolutely requires a temporary resident permit. A lot of people just go to the border and they have more discretion at their border, and they'll just pay $200 and get it there. Eventually that runs out and they are not so kind, and it will always be at the worst possible time. So it's really important. Whereas marijuana doesn't count for them, we don't count DUIs, but marijuana is super important. So
yeah, I don't have much to add to that, just in terms of, clients who might be going to TIFF. The ones that come up for me often are TIFF or Just for Laughs comes up quite a bit. You'll get calls of the week before, people needing to be there for those festivals, or if there's a production going on. Yeah, you can handle the temporary resident permit at the border, but they have gotten more strict on that, or at least filed it previously.
So we have a couple of other questions. One other question that came in. What if a client is approved as a producer on an agent-based petition? They are offered a position as an assistant producer. Can they accept that position?
The question then is going to be whether the second position that is being offered to this person is within the definition of the prior approval that they had. And that's the question. And sometimes the answer is going to be, this is a new position, is materially different or not. So it depends on the facts. Also, another consideration in those cases is that when immigration approved the first petition, the level of the position in which the person was going to be working was part of the consideration to give the person that O1 visa. In other words, what I'm saying here, what the point here is that if immigration approved you to be acting at a very high level, and now you're trying to work on a lower level, that may be considered material in some changes, in some cases. What are your thoughts on that, Leia and Zoe?
I think it's a material change because it's a lower position.
Yep.
And and again, you're right. It depends on how the petition is set up. If you said in the petition to be an assistant producer and producer, then I think you're covered. It really, and you'll see this too. A lot of people ask me, why do I have to give this whole petition to NBC or ABC to make sure that my group can appear on Jimmy Fallon? They need to see not just the approval notice is not enough. You need to see that underlying petition to see what the person is allowed to do. Everything is so dictated by the way the petition is set up. Does it include press and publicity, which you always want to put on there because it's always there. And in this example, if you have if you think they're going to be both, put both, and then you're covered. But if not, I think you have to file a change.
We have go ahead. I'm sorry.
No.
Yeah, we had a really interesting question, and this will be the last one. How will you deal with a potential RFE, request for evidence, saying the concert venue shows are closed due to the coronavirus and no shows are scheduled.
Yeah, we've been talking about this. Leah, I know you have an opinion.
Well, Michael, I see he was asking the question, you troublemaker.
You've gotten responses from USCIS on this. I haven't yet, so I haven't actually seen what the RFPs look like on this question. I know you have.
I have from California, where they're short because they were short petitions. Some of the agencies will only allow you to put in, and I guess this is a big takeaway if anybody works with any of the agencies, don't let them make up dates. It's the worst idea in the world. Everybody's calling them and asking these venues. It's just terrible.
They've got USCIS fraud units calling them up. Like, you know, do you have a comic working at this, you know, comedy club 2 years from now because it was on the itinerary?
So
you know,
don't
they will
do that. The thing with immigration and what is in their memo that covers this sort of situation is industry standard. So what the industry says goes. So what's important, let's say at a concert venue, that you explain to the immigration, these are proposed dates that will happen once we get through this crisis. I had one that was a short one because WME, so what happened is they were having all these requests for evidence and calls from the fraud units and everything else. So now you've got all the agents saying, well, we're only going to give you what you have on the books. And if you only have 3 months worth of dates, we're giving you 3 months. So those petitions, I think you're shit out of luck because there's nothing you can do to make that petition longer. You're going to have to refile once you get new dates. But for petitions moving forward, we're including the some kind of language to say these are actual dates and actual things that will happen based upon government gatherings and things like that. A letter from the promoter is going to go a long way to say we're going to have them. Letters of intent are great. You say, especially DJs, they're going to perform, or in comics, I think too, they're going to perform at this club 3 times a year. And we don't have the dates, unfortunately, because of COVID, but they will be performing here, and that is our industry standard, because that is the music industry. It's not the operas. They know everything 3 years in advance. Those are great, but the agencies are right not to be sending out dates and making up stuff anymore. Don't push them.
With comics, we might have dates for up to 6 months, but anything beyond that is unclear. So we will, the way we would word it is exactly like you said. It's 2 shows a month at commensurate salary to the previous scheduled shows with dates to be confirmed. So
we're about ended, and it's almost 2 o'clock. It's 1:58. I did have a question as to whether the attendees will be getting the slideshow. One of the attendees thought it was very useful, and I'm addressing that to Lauren or somebody from the Beverly Hills Bar Association.
Yeah, so everyone should have gotten a link to download the slideshow about an hour before the presentation started in the reminder email. Should have come around 11:30 in the morning, but it will also be sent out with the CLE certificate you all get tomorrow. And I don't know what you all get to see, but I have answered this in the Q&A as well, and there's a link there as well for anyone who wants to get a copy now.
Thank you very much. I want to thank our distinguished panelists. This is a very timely panel, it turns out. We didn't plan it that way in the beginning, but it turns out that all of these things are happening in real time. So thank you very much for addressing all these issues for entertainment attorneys, for immigration attorneys, and for people in the entertainment and other industries. And I want to thank also the Beverly Hills Bar Association for so graciously moving this to a Zoom conference when we had it originally scheduled live. I want to point out to all of our attendees that there are some wonderful Zoom conferences now that are being hosted by the BHBA, Beverly Hills Bar Association. Please go on the website and see if there's interesting things that you may want to attend. Thank you everybody for attending, and thank you to all of our distinguished panel members and the Bar Association.